Good afternoon, everyone, and welcome to our Parkinson's Resources of Oregon webinar series. Happy October. I am Melissa Greer. I am the Education and Wellness Coordinator for Parkinson's Resources, which is a local nonprofit here in Portland that also has offices in Eugene and Central Oregon, and we do serve all of Oregon and Southwest Washington. One of the things that we do, not only do we provide support, education, we have over 60 support groups in Oregon and Southwest Washington, but we do these online presentations in an effort to bring information, live information, on a variety of topics that anyone can access. We anticipate that this is going to be recorded. Fingers crossed that everything goes well with technology. And you can find it on our YouTube page within a week or two. I'm going to get started, but I definitely want to give you a quick little rundown. On the right side of your screen, you're going to see a little box that has questions. Some of you submitted questions earlier, and those have been sent to Michael, who will be going through those throughout his presentation. So keep your ears open for your question. And we will try to leave some time at the end for questions, but we have a lot to cover today, so we want to make sure that we get through all of the information. But you can submit your questions if new questions come up or you weren't able to submit your question. Feel free to go ahead and write those questions, and we will try to get to them as many as possible. If we are unable to, you can always email me at melissa@parkinsonsresources.org. Michael also has his information up on the screen right now. And I am going to, if you're also having any questions or problems, that is the perfect place to also submit your any sort of technical issues that you're having. Okay, let's get started. So today I'm thrilled to have Michael Rhodes with us, who's an elder law attorney with Rhodes Elder Law. So he's going to tell you a little bit about himself and his practice. So I'm going to hand it over to Michael.
Thank you, Melissa. Can you guys hear me? Okay, so real quick, I don't want to take too much time to introduce myself because we got a lot of information to cover. So I just wanted to show you really fast, if I can. If you want to know a little bit more about me, you can go to rhodeselderlaw.org, and then there's a little tab there you can click on about Michael Rhodes, and you can scroll down and kind of read my story and history and find out about my education and experience. So that being said, again, you guys submitted some really awesome questions, and I'm hoping that I'll be able to answer all of them. We have very little time today to go over what's actually a lot of information. So hopefully I'll get the most important pieces out. I'll be able to answer as many questions as possible. And of course, as questions come up, you're welcome to submit those, and we'll try to answer them as we go through all of this. So without further ado, we're talking about protection against incapacity. What does that mean? How can we protect ourselves from the legal and financial issues that might come up if we were to lose capacity? First of all, I wanted to just explain what it is I do as an elder law attorney, because there's actually a lot of people don't know what elder law attorneys do. So first off, elder law is essentially estate planning plus long-term care planning. So we combine the two. And elder law attorneys help clients to protect themselves, their families, and their estate against the legal and financial issues associated with unexpected health problems and death. I often hear from people, well, I already have an attorney, I've already got my estate plan done, and that's great. I'm really glad to hear that. But for people who are dealing with the potential for incapacity, right? Maybe there's a diagnosis, maybe something has happened. Often there's maybe it's like a stroke or something like that. At that point, when we're concerned that there's going to be long-term care in your future, it's really, really important to talk to an elder law attorney. This is a niche practice. Very few attorneys actually practice in elder law. and so therefore there aren't that many attorneys who are actually competent in this. As with every other area of law, this is a very complex area, and it needs somebody who has been trained and has experience dealing with these kinds of issues. So the traditional estate planning attorneys actually focus on, mostly what happens when you die. And so a lot of them are going to be focused on how do we get your property to the next generation. In assisting our clients, we help them to plan for death, but we also help them to protect themselves and their estates while they're alive. Okay. So do you need an elder law attorney? Well, maybe, maybe not, but planning for death is an important part of life. However, today it's just as important that we plan to live. The reality is that we're all living longer lives, but we're not necessarily living better lives. And it's imperative that we take steps to protect ourselves as well as our loved ones. And as an elder law attorney, what I do is I help to create estate plans for people that will protect them, will protect their family, will protect their estates in case there's some need for long-term care. Right? Long-term care presents all kinds of issues, especially if we've lost capacity. Losing capacity means that somebody else is going to have to make all of our decisions for us, and we're going to need a lot more care. So traditional estate planning attorneys don't work with Medicaid or veterans benefits, and therefore they don't draft documents that will help to protect our families if we would need long-term care. An estate plan from an elder law attorney is going to help you protect all of these things. Okay. So again, the question is, well, why do we plan? And of course, the famous quote we think came from Benjamin Franklin: if you fail to plan, you plan to fail, right? I mean, that's kind of the harsh reality. If we don't put something in place to protect ourselves, then we're left to the next available option. So what happens if I don't have a plan? Luckily, there are supports in place, right? The government has all kinds of supports to help us if we cannot help ourselves. However, the person who becomes incapacitated will need someone to assume responsibility for their personal health care and their financial needs. And a person may plan their estate while they have legal capacity, but once they've lost capacity or their capacity has been significantly diminished, it's likely going to be too late to be able to do any significant planning. So at that point, if you have not done an estate plan, then your only option, once you've lost capacity, is to ask a judge to appoint a guardian or a conservator over you, right? So now we're seeking help from the law to appoint another person to make decisions for us. So what does that mean? What does it mean to have a guardian or a conservator? Guardianship and conservatorship are different. Guardian is a court supervised proceeding to manage personal affairs of an incapacitated person, and conservatorship is simply the same thing to manage the financial affairs. Okay, so a guardianship, let's just go through the process really quick. If you lose capacity and you don't have a legal representative who can make decisions for you, and somebody needs to determine where you're going to live, what kind of health care you're going to receive, who your doctor is going to be, if we need somebody to just take care of all those daily things, then we're going to have to go to a court and ask the judge to appoint a guardian for you. And what we have to show is that you've lost capacity and that you're making decisions that are life-threatening, right? So if you have lost capacity, that's the first key. The second key is that because of that incapacity, you're making decisions that are threatening your life, and we need somebody to step in to make your decisions for you. So we have the judge does kind of his or her due diligence to find out whether or not what we've stated in our petition is true. They're going to send out a court visitor to do some investigative work to find out if you've lost your capacity. And if they determine that you have, and that because of that incapacity, you're a threat to yourself, then the court is actually going to strip you of your constitutional rights. They're going to say this person no longer has the right to make their own decisions. This person cannot choose where they live or what kind of care they're going to receive because of their mental incapacity. So now we're going to give those rights to another person. This is kind of like a parent, right? Where our parents up until the age of 18 have the right to make all of these decisions for us. And so this is kind of a similar situation. In addition, we also have what we call conservatorship. And in Oregon, that simply means that this person, if there are assets that are valued over $10,000, then the court will appoint a conservator in addition to a guardian. And the conservator's job is to protect or conserve the estate. The conservator will then take control of all the finances, pay all the bills, contract on behalf of the incapacitated person. And so guardianship and conservatorship are very different. Just because you have a guardian doesn't mean that you're going to have a conservator. And just because you have a conservator doesn't necessarily mean that you have to have a guardian. However, regardless, the process is still pretty much the same, whether you need a guardian or a conservator or both. Okay, so guardianship and conservatorship is not the best outcome. This is our fallback. This is what we get if we don't do any planning, right? And it's really important that we understand what it means to go through this process. So I just, again, wanted to let you know what the process actually looks like. When somebody needs a guardian, the interested person or the person who wants to protect their loved one is going to have to find an attorney and file a petition with the court. At the end of the day, it's going to cost at a minimum $3,000 to establish a guardian and a conservatorship, or just one or the other. If there's an objection, the objection could come from our incapacitated person because they still have their rights, or it could come from another interested party. So it could come from another one of your loved ones. If there's an objection, at that point we have to go into court and basically have a hearing. And so the price of a guardianship or conservatorship is going to go up from there. In addition, there's also what we call a temporary guardianship. Some people call these emergency guardianships. We see these often when somebody goes into the hospital and they don't have capacity, but they need to be released by the hospital. The hospital will not release that person unless a temporary guardian is appointed. In that situation, you're looking at probably $4,500. So guardians and conservators are also required to file reports with the court each year, and these reports can be costly. They can easily be $1,500 a year or more. And just so we're clear, our incapacitated person is the one who is going to be paying for all of this. So that's not the best outcome, right? It is a public proceeding, so therefore it's potentially embarrassing and intrusive for the incapacitated person. When a judge determines that you no longer have your capacity, they're essentially going to strip you of your rights. They're gonna say you no longer have the right to make your own decisions. Somebody else needs to do this for you. So we're going to give those rights to somebody else to manage. Okay. So how do we protect ourselves against guardianship, against conservatorship? What can we put in place to ensure that we don't have these kinds of problems? And the legal documents on the face, they're very simple. Power of attorney Advanced Directive. Those are going to be the two most important documents that you can have in place, the two very most important documents. A post is in addition. I just wanted to throw that in there, and the Revocable Living Trust is also a great tool. Some people asked about that, so I'll talk just a little bit about that. At the end of this, I will talk a little bit about Medicaid. So hang tight. I wanted to just get into the power of attorney, the Advanced Directive, a little bit more in depth, because these are really, really important documents. So let's talk about the power of attorney. The durable power of attorney, in my estimation, is going to be your most important legal document. It can do all kinds of things for you. Again, this is going to be you exercising your agency or your constitutional rights to appoint another person to make all of your decisions for you. And essentially, a power of attorney is an employment contract. You are the employer. You're the one who gets to designate who you want to act on your behalf, and you are in your document telling them essentially what they can and cannot do. And your agent is your employee. So that agent, while you have capacity, you're in control. You're the boss. You're the one that gets to call all the shots. So I have people all the time say, well, you know, I don't want to sign this power of attorney yet because I don't want this person to have control of my assets yet, and totally understand that. But while you have capacity, you are in control. You're the one that calls all the shots. If somebody is taking that, or if your agent is taking the power of attorney and misusing it, then you need to hold them responsible, right? There's no reason why your agent should be misusing that power of attorney document. But once you lose capacity, that's when your agent has what we call a fiduciary responsibility to act in your best interests, okay? Just because they have power of attorney to act on your behalf, they must still try to make the decisions that you yourself would make if you were in the situation. So their responsibility, that word fiduciary, essentially means trust. That you're trusting them to put themselves in your shoes, to think about what it is you would want in any particular circumstance and to make that decision, okay? So the power of attorney is really important. It's an employment contract. It must be in writing and it must be notarized. Just the word durable actually means that it's going to survive your incapacity. Okay, and many, many years ago, we had power of attorney that essentially stopped working once you lost your capacity. And the state said, well, that's a bad outcome. We don't want this power of attorney to not work once you've lost capacity. So they essentially said, okay, we're going to make a durable power of attorney. So now we've got these durable power of attorney. In the state of Oregon, most powers of attorney are going to be durable. They're going to survive your incapacity, which is exactly what we want. We want somebody else to be able to manage all of your finances, your obligations, your financial contracts on your behalf if you lose capacity. However, this power will terminate at your death. So when the boss dies, the employee no longer has a job, right? I have a lot of people, this happens actually fairly frequently, where somebody will come into the office and say, well, mom's died, but I'm her power of attorney. And we have to say, well, that's nice, but you know, you actually have no authority anymore. At that point, we need to find out either if there's a trust in place and who the successor trustee is, or if there's a will and who the executor of the will is. So your durable power of attorney will only last as long as you're alive. Once you've died, that power ceases to exist. The most important part that I really want to hit here is about this idea of your power of attorney being strictly construed. That simply means that if you want your agent to be able to have authority to do something on your behalf, that authority must be explicitly granted in your document. So there are a lot of power of attorney documents out there that you'll find that will say, well, I give my agent authority to do anything and everything that I could do. Well, that's nice, but if it doesn't explicitly say that your agent has the ability to manage your bank account, then guess what? They don't have authority to manage your bank account. And if they take that document to the bank and they say, hey, I need to, withdraw some money from mom, they're going to say, well, you don't have authority to do that. And banks are very, very strict on this rule. Okay, it's really important that if you want your agent to be able to have authority to do something on your behalf, you must state it explicitly. And this is where we see probably the most problems come up with power of attorney. So often somebody will come to the office and say, hey, we got this power of attorney from the bookstore, or we got it online, and the bank won't accept it. And then they want me to go and force the bank to accept it. Number one, I cannot force a bank to accept your power of attorney. Number two, we want to look at why. Well, why is this bank not accepting your power of attorney? And there could be a multitude of reasons, but what I see often, and this is a good example, is financial advisors. So let's say you have a brokerage account or an IRA or something with a financial advisor, and if it doesn't explicitly state in your durable power of attorney that your agent can manage your financial accounts or your investment accounts with your financial advisor, guess what? They can't do it. And that's a really big problem. I've heard of that problem many, many times. So that being said, not all power of attorney documents are created equal. There are all kinds of power of attorney documents in the world. There's, you could literally come up with a billion different kinds of power of attorney documents if you wanted to. Not all are created equal. So it's really important for you to know, number one, what you have to protect or what you need your agent to be able to do on your behalf, and number two, what kind of language you need in the document to allow your agent to do that. So we often compare power of attorney documents to like pocket knives. And so there are all kinds of pocket knives out there. There are all kinds of power of attorney documents out there. The power of attorney that you're going to get from like a bookstore or online it can be very, very useful. It can be very, very handy. Could be very, very effective for your situation. However, I do want to caution you that those kinds of documents are, I hate to use the word generic, but they're all kind of boilerplate. And it is likely that there is something missing from that document that you may need in order to protect you. And so I always tell people when they ask me about bookstore documents, number one, they say, are they legal? Will they hold up in a court of law? Yes, they will, right? I mean, once you sign it, it's an employment contract, it's legal, it will hold up. But the question is, will it do what you need it to do? Because if the power of attorney fails to provide for a specific instance, then that power of attorney becomes ineffective. And in that situation, even though you've got the power of attorney, you may still need to have a guardian appointed or maybe a conservator appointed. So it's really important to have a power of attorney that's going to be effective, especially when you've lost your capacity and somebody else is going to manage all of your personal finances and assets and contracts. You really want a power of attorney that is going to provide for all of those situations. So again, people will ask me, well, is the bookstore document or the online document going to be sufficient? Maybe it is. Usually I look at that situation and say, well, are you married or single? If you're single, okay, maybe. If you're married, probably not, because those documents don't do a very good job at protecting your spouse from your incapacity. If you have very few assets, if you have very few obligations, then maybe the bookstore power of attorney is going to be just fine for you. But if you have a spouse if you have assets that need protecting, you really should have a power of attorney that is going to help protect you and your family and your assets. And just because a document says it's a power of attorney doesn't mean it's going to give you the protection that you need. It's got to have that specific language. So let's go ahead and look at what some of that specific language might look like. So there's just a few sample clauses here. First is going to be gifts. You want to have the authority to be able to make gifts, especially gifts to your agent or transfers to your spouse. You want to be able to provide support for your spouse or assistance in your home. You might look at these and say, well, what's the big deal with these? And a lot of this really comes down to if you need some kind of government support for your long-term care. Let's say you've lost your capacity, you can no longer manage your own assets, and your spouse needs to qualify you for government benefits to be able to pay for long-term care. And some of the nice things are that with, say, Medicaid, we can actually transfer assets to our well spouse, and that will help our ill spouse to qualify for Medicaid. But if in your power of attorney it is silent as to transfers to your spouse or gifting powers, then Medicaid says, sorry, you're not allowed to do that because your document does not provide for that. Okay, so these types of clauses are really, really important. So if you're married and you're concerned about protecting your estate in the event of long-term care, you should include these types of clauses. And of course, I wouldn't recommend that you just copy and paste what I have here because it's not it's not going to cover very effectively what you would need. If the power of attorney document is silent on any of these issues, we actually assume that you did not want your agent to have that authority. So that's, going back to what I said earlier, if you've got a power of attorney document that says, I want my agent to be able to have all the power, do anything and everything that I could do, that's just not good enough. We don't want to assume more. We want to assume less in order to protect you or to protect your estate. But if you want your agent to have that authority, then it's necessary that you state it explicitly in the document. Okay, so that's the document itself. I do want to caution you, we call the power of attorney the keys to the kingdom. Okay, so it is unfortunately the most common form of elder abuse occurs when an adult child misuses the power of attorney. And if you're incapacitated, some people say, well, if I'm incapacitated, no big deal, but it really can be a really big deal. And especially you don't want somebody misusing that power of attorney document when you do have capacity, but maybe you're too feeble and unable to protect yourself against it. So you want to make sure that you exercise caution in selecting an agent. You're going to want to think about very seriously who you would want to handle these things on your behalf. Number one, and this happens all the time, I have people say, well, I'm going to name my child. And I say, well, tell me about your child. Are they married? Are they working? Do they have kids? So I kind of go through this whole series of questions and say, is this person going to be the right person? And when we start talking about it, they say, well, he just filed for bankruptcy 3 years ago. Well, if he can't manage his own finances, he's not going to be able to manage yours. And that's what we're asking him to do. So it's probably not fair to him if he can't manage his own finances to ask him to manage yours, right? I would also consider the age and family dynamics of your agent. Are they, I had a family member say, hey, I want you to be my power of attorney, Michael. And I just looked at him, I said, I'd love to do that for you because you're my family and I want to help you, but I've got 2 little kids, I've got 1 on the way, and I am extremely busy with my law practice, and you live a couple of hours away, and so it's not really a good idea for me to be your agent? You know, I could be a backup maybe. Maybe let's try and do that. I'll be your backup, but let's try and find somebody else that might have more time and ability to help you out. Really think about who your agent is, and be smart about who you choose. It's always nice to choose kids, you know, for one reason or another. The one thing that I don't like to see is a parent choosing their child just because they think the child will be hurt if they're not chosen. And that does happen. But that's a really, really, really bad reason to choose somebody to be your agent. Okay, what about springing powers? So there is what we call a springing power of attorney. The springing power means that your power of attorney document does not actually, or is not actually effective until it's been proven that you've lost capacity. So in your power of attorney document, it will say something to the effect of, this power of attorney will not be effective until a doctor and another knowledgeable doctor agree that I'm incapacitated. So in other words, you have a completely useless document until two doctors agree that you've lost capacity. And these tend to be a real problem for us. And I've heard a lot of clients say, well, I like that because then I know that they're not going to misuse it. Well, let me just shed some light on this. If you cannot trust your agent while you've got your capacity, what makes you think that you can trust them when you don't have your capacity? So I always say the springing powers cause a lot of problems. Last year I had a woman come into the office and say, Mom's losing capacity and she needs help with finances. She will absolutely not let me help with her finances, and I cannot get a doctor to agree that she's lost capacity. We actually hear this pretty commonly with these types of powers of attorney. They end up becoming a hindrance. They end up really ruining the estate plan. And in that situation, we had to actually file for a guardianship. Mom had done her planning, but because of these springing powers and the fact that we couldn't get the doctor to say that Mom was incapacitated, we actually had to file for a guardianship to protect Mom from herself. And that was a sad situation. At the end of the day, I think it was the right thing to do, and I think that Mom is better off because we've got the protection that she needed, but it's not the way that she would have wanted it. And I think that if she would have really considered what she was doing with that power of attorney, that she probably wouldn't have put those springing powers in there. So I never recommend springing power of attorney. I always recommend that you sign a power of attorney that's going to be effective immediately. So what about people who don't have family members or friends that can act on their behalf? And I mean, this is the reality, right? I mean, not only are people, maybe you can't trust them, or maybe it's something more along the lines of what I shared before, where I'm just too busy. I don't have the time or the means to be able to be my family member's agent. I will always talk to my clients about professional fiduciaries. Professional fiduciaries are people who are in the community who will do this sort of work. They do it for a fee. They do charge for their time, but they're very good at what they do. They've done this a lot typically, and they know what they're doing. And for the most part, what I see when a professional fiduciary is acting on somebody else's behalf in the role of agent under a durable power of attorney, that the bills, it really doesn't cost a whole lot, maybe $100 a month or something like that, for them to take over paying your bills, making sure that you're well taken care of. Professional fiduciaries are great. I've got a list of them I can share with you. There's also a list online I can send you the link for if you're interested in looking at professional fiduciaries. I think they're wonderful, and I will always recommend them for various reasons. But the question is, who can you trust, right? So exercise caution when you're signing a durable power of attorney. It's really, really important. Okay. So that was the majority of our time already spent on incapacity and power of attorney. Let's talk really quick about the Advanced Directive. The Advanced Directive is actually a statutory form. That means that there's really only one out there, unless you get it from an attorney, and then they might spice theirs up with a little bit of extra language. But the Advanced Directive you can get for free. You can get it online. You can get it from an attorney. You can get it from your doctor. Everybody who is over the age of 18 should have an Advanced Directive, as well as the durable power of attorney. But the Advanced Directive is for is two things. First of all, it combines both the living will and the durable power of attorney for health care. So the Advanced Directive has two main objectives. First of all, you have an opportunity to appoint a healthcare representative. This is a durable power of attorney for your healthcare. If you are incapacitated and cannot make your own decisions with regard to healthcare, if you don't know what's going on, but there's a doctor seeing you for whatever health reasons, and somebody needs to okay certain treatment or certain medication, you need to have somebody who can speak for you. In the Advanced Directive, you have an opportunity to nominate at least two people who can make decisions for you with regard to your health care. Okay? The second part of this is going to be the living will. And the living will is where you get to express your wishes with regard to life support and tube feeding. And they give you four scenarios. They say if you're close to death, permanently unconscious, have an advanced progressive illness, or you're in extraordinary suffering, do you want life support? Do you want tube feeding? And your responses can be yes, no, or only as my physician recommends. Now, I have a lot of clients that say, I don't want anything, and that's fine. There's Section 5. It simply says that I don't want my life to be prolonged by life support or tube feeding as long as my doctor and another knowledgeable doctor agree that I'm in one of those four conditions listed above. Please just let me go. And that's a perfectly acceptable choice. I just want to point out two places in the Advanced Directive where you have an opportunity to express your wishes. And I highly recommend that you fill those out. Take some time to think about what kind of care you would want, or what kind of things you would want your agent to do for you. This is a chance for you to be thoughtful about what it is that makes you feel good about yourself or makes you feel like a human being, and just write them in. So that's the Advanced Directive in a nutshell. Just as a heads up, the Oregon legislature did approve changes to the Advanced Directive, and those changes will take effect January 1st, 2019. Fear not, this will not disrupt your current Advanced Directive. You will still be able to, your Advanced Directive, if you signed it today or even 10 years ago, it will still be effective. Okay. The POLST, this is a really important document. It's something you can only get from your doctor. An attorney can't help you out with this. We could give you the paper. It would be meaningless until you took it to your physician. So what is the POLST? It's the physician's order for life-sustaining treatment. And what it does is that if you collapse and your heart stops beating and you've stopped breathing, and EMT is called to your house to come and administer CPR, EMT is duty-bound to try to resuscitate you. They will do everything they can to try to bring you back to life. So that's going to include normal things like CPR, and then maybe using the shock paddles, right? They're going to try to bring you back to life. And for a lot of my clients who are advanced in age, they say, you know what, I understand that when CPR is administered, they're going to break ribs, it's probably going to puncture my lungs, I'm going to be bruised from head to toe. I'd rather just die. Well, unfortunately for you, the medics, as I said, they're duty bound to try to save your life. So what can you do? Well, you go talk to your doctor. The doctor is the only one that can tell the EMT to stand down. So that's what the POLST form is. It's otherwise known as a do not resuscitate order from the doctor. So the doctor, it's a pink sheet. You've seen it hanging on people's fridges, or you've seen it in a hospital. It's a really important document that if you don't want to be resuscitated, you need to let your doctor know that, and he or she will sign that POLST form for you. and then you put it somewhere conspicuous so that when EMT arrives, they know what your wishes are. This is not the same as the Advanced Directive. The Advanced Directive and the Post are very, very different documents. They do very different things. So make sure that if you do not want to be resuscitated, that you talk to your doctor. Okay. Really quickly, revocable living trusts are really great estate planning tools, but we have to be really careful when we create a trust for a family who's expecting long-term care. More often than not, if you're expecting long-term care and you have a revocable living trust in place, the elder law attorney is going to throw out that revocable living trust and create a whole new plan for you. Because most, as I said, traditional estate planning attorneys create plans with the idea that you're going to die, but they don't really create plans with the eye that you're going to live and have these significant health issues. And a couple of the problems that we see is that when you become incapacitated, your trust actually becomes irrevocable. And that's a really tough position to be in, especially if you're married, because now your assets are locked up and we cannot transfer them to our well spouse to help protect them. So now we're going to end up in a situation where we may be spending down all of your assets in order to pay for your care before you qualify for Medicaid. Whereas if we had the proper plan in place, we may be able to help preserve quite a bit of, or at least a respectable amount of your assets for our well spouse while our ill spouse qualifies for Medicaid. So a trust drafted by an elder law attorney can really help to reduce any of these potential problems. So at the end of the day, the most we can do is the most we can do. And I know that that does sound trite, but even with the best estate planning documents on the market, there's no guarantee that a person will not need a guardianship. Okay? And this could be for many, many reasons. However, the most common is that our ill person is not allowing or is refusing to work with their appointed agent. Remember, you still have your rights. You've got your constitutional rights, and you're the boss. And if you refuse to work with your agent, you're essentially firing them from their job, so they can't do it. So we see this not super frequently, but we do see it often where the incapacitated person is not wanting to work with their agent, and we will end up needing to go to court to have a guardian appointed. It's not necessarily the best outcome, but guardianship, I do want to just say, guardianship and conservatorship aren't the end of the world. It's the best that we have to be able to protect you in a very serious situation. There are a lot of horror stories out there, but I would say that the majority of cases are not those horror stories. The majority of cases, the guardianship conservatorship is a very, very good thing for our clients. And at the end of the day, your best defense against this guardianship or conservatorship is going to be creating and executing a very smart and thoughtful estate plan. More often than not, your estate plan is going to be sufficient to protect you against these things. Okay, I know I'm going really, really fast here. I wanted to cover as much information as I can, as well as give some time for questions. Hopefully there's some questions out there that you guys want to ask, and I hopefully be able to answer them. I just wanted to point out in the last few minutes here, there was some questions about Medicaid. And this is a really, really important issue, right? If you're experiencing memory loss, or we anticipate that you're going to need long-term care, that care is going to be really expensive. The state of Oregon actually says that the average cost of nursing home care in the state of Oregon is $8,784 a month. For a lot of us, that is a deal breaker. It is so expensive. And it's really difficult, especially for a married couple, when we have an ill spouse that needs long-term care and our well spouse is staying at home. How are they going to pay all of these bills? They're going to run out of money pretty quickly. So this is a really important issue. There's several ways to pay for long-term care. First of all, the best way is if you have long-term care insurance. and very few people have long-term care insurance. But if you've got it, that's wonderful, and it's gonna be a boon to you. The other way is going to be privately. You're going to be paying from your savings, from your income, from your IRA, 401k. You're going to use cash from life insurance policies, and you may, some people end up selling their home. Now, that is one way to pay privately. However, I just want to throw in a little caveat right there that you don't have to go that far, okay? But that's kind of the reality. Most people say when they're going to pay privately, that's how they're going to do it. Okay. You can also have family help you pay. That does happen pretty regularly. But you can also qualify for government benefits. There's VA aid and attendance, which is a supplemental pension for veterans that can help pay for long-term care. And then there's also Medicaid. And Medicaid and VA are very different, although the rules are very similar. They're very different in how they work, and that's a topic for another day. But for individuals needing long-term care, more than 50% will need government benefits to help pay for these costs. So it's important that we understand how Medicaid works. So Medicaid qualification has 3 parts. First, there's got to be a medical need. We call those activities of daily living. Your income must be under $2,250 a month, and your assets must be below $2,000. Now, everybody just kind of stops there and says, well, I'll never qualify until we're dead broke. Well, maybe, but maybe not. And it's really, really important that you take the time to learn about how the rules work, especially for married couples, because there is a lot of exceptions for married couples, okay? So I'm not going to go through these things here right now because we're definitely running out of time. But I want you to know that for a married couple, there is the federal government enacted the Spousal Impoverishment Act back in the late 80s. And that essentially says that where there is a married couple, we don't want our well spouse to become dead broke or impoverished just so that our ill spouse can receive government aid. So the bottom line is that a well spouse can keep a respectable amount of assets while their ill spouse can qualify for Medicaid. And if you work with an elder law attorney, the elder law attorney can really help you to preserve and protect more assets while allowing your loved one to qualify for Medicaid. So I know that there may be some questions. Oh, the one thing I did want to mention, there was a question about Medicaid divorce. That was a thing many decades ago, but reality is you should not have to get a divorce in order for your spouse to qualify for Medicaid. In fact, divorce may actually hurt you more than help you. And some people might say, well, I just want to get divorced anyway, and I understand that. But a lot of my clients, they don't want to get divorced, and you don't have to. We can figure this out. We can find a way for you to be able to keep more of the assets so that you don't go broke or become impoverished while your loved one gets the help and the care that they need. I'm going to just answer one more question that kind of came up as far as Medicaid. Somebody asked if they could quit their job and then Medicaid would pay them to be an in-home caregiver for their spouse. Maybe. That's possible. Medicaid does pay for in-home care in certain instances. But the reality is when it comes to in-home care, they have to, your ill spouse will have to meet a certain level of care need. And when it's a spouse providing the care, they essentially say that your spouse will have to have nursing home level needs for care, which essentially almost means 24/7 care. And that's really difficult for most spouses to do. And the hard part of that is that if you do participate in this program, they're not gonna, they won't allow you to work more than 40 hours a week. You could only work that much and get paid for that much. And after that, if more care was needed, you'd either be doing it for free or you'd have to hire somebody else to do it. So I hope that answers that question. If there are other questions, Melissa, let me know, or I'm happy to try it. I could even just kind of bring up the email that you sent to me, Melissa, and kind of go through that as well. I am not licensed, and there's a question here that says, am I licensed in the state of Washington? I am not, but I've got contacts in the state of Washington, and that can help you out with that, licensed attorneys up there. The second part of the question, are these documents transferable from state to state? When I'm assuming that when you say these documents, you're talking about power of attorney, you're talking about advanced directive, trust. Yes, they are transferable. So the documents, if you get them done here in Oregon, they will recognize them in other states. Now, that being said, if you are planning to make a permanent move to another state, I always recommend you get state-specific documents, because every state is different. Their laws are different. The way they run the Medicaid program is different. I always recommend that you speak to an elder law attorney in the state that you're going to live, to get the appropriate documents for you there. Should a spouse be designated with power of attorney ahead of a child or other designee? That's a great question, and oftentimes, so the question is, should I put my spouse first on the power of attorney? And often the answer is yes. It makes sense, right? As if you're a married couple, your spouse, as long as they're healthy and able to manage, it's a good idea to have them be your first agent. They're going to be the one to have the most ability to help you out. But not always is that the case. And we have definitely had situations where we've got both spouses who are experiencing some symptoms, potentially of dementia, or there may be some other health problems, concerns going on there, where we just say, you know what, we're going to help you sign a power of attorney, both of you, and each of you are going to nominate a child and or another person to be your agent. So not always do we have the spouse as first. Great question. So another question, when considering being a personal advocate, can you address the concerns of doing so as a non-family member? You know, I'd say that there's a lot of concerns being like an agent under a power of attorney for somebody who's not a family member. However, the biggest concern is simply your own wrongdoing. So if you're doing something wrong and it's intentional, you're going to be held responsible for that, right? That can be elder abuse, and the elder abuse laws are very stiff here in Oregon. But as long as you're trying to do the right thing, even if you make mistakes, you're going to be okay. And the biggest issue I see is that if we've got a person who's losing capacity and they've got family, but they've nominated a friend over the family, then you're going to be caught in between dealing with a person who's lost their capacity or is losing their capacity and their family. And that can be a real nightmare situation sometimes. And that's where I say, you know, professional fiduciary might be better off. Number one, they've been trained. Number two, they've dealt with this a lot. Number three, they're getting paid to do it. So, you know, they're willing to put up with it. At any rate, I don't think there's a lot of other concerns about being an advocate for somebody who's not a family member. Great question. Okay. Do you know the average cost of in-home care if nursing home costs an average? No, so they want to know if I know the average cost of in-home care. So in-home care is going to start out with probably an hour a day, and can rise to 24 hours a day, right? So I don't know what the average cost of care is in home, but you know, you could probably assume that if it's somewhere between 1 and 24 hours a day, that it's going to be on average maybe $10,000 a month, because 24/7 care is easily going to cost $20,000 a month in home. So I hope that answers that question. I don't know. I don't have an actual statistic on it. Next question.
Looks like those are all the questions that have been coming in. If there's any others, please submit them because we have a few more minutes. Or Michael, if there's any of the other questions that you'd like to address, or we have about 5 more minutes that we could go back and get some more information if you'd like.
Okay, let me see. I'm going to find your email here. And of course, I'm not seeing it. See if I can remember any of the other questions. I tried to answer all of them, so there might be a few. Oh, here we go. See if there's any on here that I might. Oops, sorry about that. So, I mean, the big one is Medicaid Spin-Down. That one's a really, really important question. I definitely don't have time to cover that. I'd love to talk to any individuals out there who are interested about Medicaid Spin-Down. Again, what the rule says is that, especially for a married couple, if there's a well spouse, the well spouse is entitled to keep 50% of the assets up to a maximum of $123,600. So that's just the rule on its face. There's a lot more that we can do to help with Medicaid Spin-Down and helping to protect assets for our well spouse. So that would be a question we could discuss, maybe in person or maybe quickly in a 20-minute phone consultation. Let's see. At what age do you recommend a married couple see you as an elder law attorney versus seeing a traditional estate planning attorney? Yeah, you know, I actually help all clients of all ages. It really depends on you and what you are most concerned with. So traditional estate planning attorneys are great for transferring assets, especially for large estates. So if you've got an estate that's, you know, several millions of dollars, and you're not concerned about long-term care, maybe you've got long-term care insurance, and what you're actually interested in doing is setting up some kind of a trust fund for grandchildren, like you're going to skip your own children for tax reasons and pass on your estate to your grandchildren. A traditional estate planning attorney is going to be great for that. I will say that with the new tax laws, a lot of this is becoming not as important. I help clients with, you know, estates valued up towards $4 million all the time with their estate planning. So it really just depends on you. It depends on what you want. When you're concerned about long-term care, that's when I say you definitely should see an elder law attorney. But again, if you've got a lot of money and you're not worried about how you're going to pay for that long-term care, then a traditional estate planning attorney would probably be just fine. Can an individual on Medicare seek coverage under a Medicaid program? So yeah, so Medicare and Medicaid are two very different programs. Medicare is going to be your health insurance program, right? So Medicare is there to pay for doctor's visits, help pay for medications, and all those sorts of things. Medicaid, now there's two different Medicaid programs, so people get confused with this. In Oregon, there's Medicaid for younger individuals who don't have enough money, and it's what we call Oregon Health Plan, right? So Medicaid for younger individuals will be essentially their Medicare. It will help them to pay for doctor's visits, and etc. In this instance, we're talking about Medicaid for long-term care, which is entirely different. Medicaid for long-term care recognizes that a person is in long-term care and the cost is exorbitant, they're not able to pay for it, so the state steps in to either make up their shortfall or pay for their full cost of care. So yes, if you're on Medicare, you can be on Medicaid as well.
Okay, I think that's all the questions that we have that are coming in. So I think that I'll say thank you, Michael, so much. You have your information up on the screen. So if people have questions, are you open to them emailing you directly?
Yeah, email me directly. That's the easiest way. I may not be able to respond right away, but I try to respond the same day. That's always my goal. And that's the same for phone calls. If I can't answer right away, I try to respond the same day.
All right, I think that's a pretty good goal. Participants can also email me as well. Again, that's melissa@parkinsonsresources.org. Thank you again, Michael, so much. That's so much information and it's so helpful. So appreciate you taking the time to work with us on this webinar.
Yeah, my pleasure.
Thank you, everyone, for participating. Again, a video recording of the webinar will be available on PRO's YouTube channel within the next few weeks. And you can find that link on our website at parkinsonsresources.org. This concludes our webinar broadcast, so stay tuned for the next webinar in 2019. Thank you so much.